I'm Christopher Hanson at Hanson Law Firm, and welcome. Today I want to talk about the new California Association of Realtors forms that have been put out in response to the COVID-19 coronavirus pandemic. California Association of Realtors, as you know, is a trade association that represents real estate licensees throughout California. It has reacted nimbly in terms of getting out forms to its constituency for use in the next several weeks, months, with regard to transactions that are currently pending and new listings that are going to be coming on board and new offers that are going to be coming on board. The California Association of Realtors, C.A.R, is fond of using acronyms for their forms. And so one of these forms is the CVA, the other is the NUCC, the other is a PEAD, and the last of these four forms is the RLA-CAA. Really? Most of these forms are nothing but C.A.R acting to CYA.
What?
Now, I've been a member of the California Association of Realtors for more than 40 years, and I appreciate that its efforts are designed to protect the real estate licensees in the state. I'm not always a fan of the way that the C.A.R forms protect the buyers and the sellers that those licensees are supposed to be representing. And these four coronavirus forms are a pretty good example, in my opinion, of how the California Association of Realtors is less concerned about their clients, actually less concerned about the customers of their clients than they are about their clients, the real estate community. So while these forms may be perfectly appropriate for a buyer and a seller in many situations, I would urge every single buyer and seller to think carefully and read carefully before they sign off on any of these next forms. So let's deal with them in order. The Coronavirus Addendum or Amendment form, the CVA. Now, this form is called Addendum or Amendment. Why? Well, the astute people in the room will understand that an addendum to a contract is something that you are adding to a contract before it has been executed. It is as if you ran out of room on page 1, and so you're making an addendum that you're going to attach to the back of it to continue to discuss the thing that's on page 1. Okay. An amendment to the contract is a change to an already executed agreement. Now, it's certainly appropriate or legal to amend a pre-existing contract. But when you do that in California, the law requires that there be some consideration for your doing so. If you're going to change the terms, you're supposed to get something in exchange for changing an already existing agreement. And so as you read through these forms, ask yourself, what are the buyer and the seller getting as they amend the already executed agreement? So where this comes up primarily is with regard to the liquidated damage provision of a purchase agreement. So we've put together a paper. It's available on the law firm's website. Feel free to download it. And if you need some bedtime reading, you can go ahead. But I'm going to use an example that I used in that memo. Let's pretend that you've got somebody that's got a $30,000 down payment on $1 million house. Here's the memo. And that deal is supposed to close March 25th. Everybody has signed off on escrow instructions. The loan is getting ready to be funded. And on March 25th, the governor says, everybody stay in place. And the market tanks. And the buyer was going to get their down payment money from selling stocks. And now the buyer hasn't got any stocks to sell, or the value of those stocks have been depleted dramatically. Or the bank says, well, wait a minute, our staff is disrupted right now and we're not going to be able to process this loan quickly enough. But the buyer has already waived all contingencies, including the financing contingency. The closing date was supposed to be what? April 25th? April 25th comes and goes and the escrow doesn't close. The liquidated damage provision says that the seller is now entitled to keep that $30,000. Is that fair? Well, let's further pretend. The seller, in anticipation of selling this $1 million house, has bought a $2 million house. And the seller has $60,000 as a down payment on that house. And it's supposed to close March 26. Now, when the March 25 sale for $1 million doesn't close, that seller's not able to buy the second one for $2 million. And that seller says, well, you've got a $60,000 liquidated damages clause, and I want it because I've got a child that's got cancer and I've got no medical insurance and I need that 60 grand to pay for his care. Is it still not fair? The form that the C.A.R. has put together doesn't address those issues. And one of the things that the CVA form makes note of is that the residential purchase agreement that has been used by the California Association of Realtors and all of its constituency doesn't have a force majeure clause in it. There's nothing in the template residential purchase agreement that allows for an unexpected, unanticipated event to act as a basis for a delay in the closing of escrow. Now, what the C.A.R. form does is says that in recognition of the obligation to act in good faith and to deal fairly with one another, this CVA form has been prepared to more completely express the agreement between the parties. Well, that's all well and true. There is an obligation to deal in good faith and to deal fairly. But this agreement has already been formed. And dealing in good faith doesn't mean that you are now required to give up a right that you've already bargained for, like the ability to keep a $30,000 or a $60,000 liquidated damages amount. So what the California Association of Realtors is trying to do with this Form CVA is create an avenue for the buyers and sellers to reach an agreement that will allow a continuation of a closing date, assuming all things can be continued. And more importantly, what this form is attempting to do is eliminate the real estate brokerage community being drug into litigation between the buyer and the seller when they start arguing about who's entitled to the liquidated damages amount under a purchase agreement. So, the next thing that the CVA form does is it says that in order to use the criteria within the CVA form, you need to submit this next form, which is the Notice of Unforeseen Coronavirus Circumstances. So the first form, the Coronavirus Amendment or Addendum, says that here's what's going to happen if someone has some impact as a result of the coronavirus. And then the next form is, by the way, we've now been impacted by the coronavirus. And so when you look at the NUCC form, it sets forth what some of those impacts can be. One of them is loss of income. Well, okay, that makes sense. How many people now? There's 6 million unemployment applications in 1 week, followed by an earlier week of 3 million unemployment applications. The economic chaos that the coronavirus has spread around the country and California is unprecedented. And we all acknowledge that. We get it. So if you have lost a job, if you have a delay in a notary appointment, that is a cause that would allow you to continue your closing. I'm not quite sure that would qualify. If there's a lender delay in funding, okay, that would make sense to me. But there are more opportunities to list which would give rise to the use of the coronavirus amendment. And one of them is difficulties in scheduling inspections. Okay, that makes sense. There are termite inspectors and roof inspectors and all of those folks who are being told to shelter in place. So that would give rise to a delay in the due diligence period of a sale. But in a closing, well, those inspections have already been done. So I don't know that that would count. There's a delay here in getting movers. Well, you know, at first blush, that seems kind of silly, but it makes sense. If you can't get a moving crew to come in and pack up your stuff and move you, then is that a coronavirus-triggered event, a pandemic event? Well, it's a governmental order that has triggered the movers from stopping work for the next 2 weeks or perhaps 2 months. And then there's one in here that is the final verification of condition. Final verification of condition isn't a contingency in the contract. Why in the world would it give rise to being a basis for a continuance of the closing on a corona amendment? So then there's yet a third category of bases to use the NUCC form that would trigger the CVA, Coronavirus Amendment. First is a confirmed diagnosis of COVID-19. So as an infected person, this real estate form requires you to advise everyone that you are infected. That's a HEPA violation, isn't it? Inquiring minds want to know. The next one is COVID-19 hospitalization. Well, okay, that makes sense to me. Governmental quarantine is one of the criteria. Well, right now in California, everyone is under governmental quarantine unless you are a medical provider or a first responder. And I don't think medical providers and first responders are buying up a bunch of houses right now. So everyone would be able to use this criteria as a basis for that CVA form, automatic continuation of a contract. And then there is other. Just other. Come up with a reason. Other. Now, the form requires you to verify your reasons, to verify that you have been under governmental quarantine, or that your mover has refused, or that you have lost your job, or any of the other criteria. But it doesn't say how exactly you are supposed to verify this. Are you supposed to give a copy of your termination notice? Do you have to give an email of the movers saying, no, they're not going to move you? Do you have to print out a copy of Gavin Newsom's governmental order quarantining everybody or having everyone stay in place? Apparently you do. And then we go to the next form. And the next form is the Property Entry Advisory and Declaration. Now this is a declaration. You are going to declare something when you sign this form. I've never seen, and I guess we live in extraordinary times, but I have never seen a situation where a prospective purchaser needed to make an affirmative declaration of any fact before they were allowed to inspect a piece of property that is on the market. We live in extraordinary times. So this form notes that real estate is an essential activity. I'm not sure that Governor Newsom's declaration made the buying and selling of homes a necessary activity, an essential activity, but apparently the drafter of the form believed so. This form says that you, a prospective purchaser, and a seller who was allowing a prospective purchaser into your house, are acknowledging that showing or visiting properties may be dangerous or unsafe, and that you are doing so at your own risk. Okay. And then the form says that you, the prospective purchaser and the seller, will take all reasonable and necessary precautions to protect yourself. All. I'm a lawyer and I deal with words. All is an awfully broad mandate for you to take to protect yourself. Because if you haven't done everything, you have just assumed liability for yourself. Then you are making a declaration that you are not, to the best of your knowledge, currently afflicted with COVID-19, and you have not knowingly come in contact with anyone who is currently afflicted with COVID-19. COVID-19 is asymptomatic, and part of the reason for the pandemic's spread is that people are being contaminated by those that they do not know who are. And the incubation period is 14 days. So I guess that this means that you would need to not go to inspect a house for at least 14 days from the time that you signed this form, because you would need to know that you are not currently afflicted. And the only way that you could know that is by waiting 14 days from the time that you've signed this. Then this form says that you believe you are not likely to transmit or contract COVID-19. Ladies and gentlemen, the Center for Disease Control has said that approximately 50% of the population of the United States will, within the next year, contract COVID-19. 50%. How in the world can anyone declare that they are not likely to transmit or contract this disease? Yet that is what you are declaring in this form. And you will be held liable for any damages that result from a breach of this declaration on your part. Then this form says that to the extent available, you will wash your hands with soap and water. You will use hand sanitizer. You will wear rubber gloves. You will wear a protective face mask. And you will wear protective shoe coverings, if any of those things are available, before you walk into the house that you wish to inspect, to purchase. Oh, and by the way, those things, those masks and booties and gloves and soap and water, are to be provided by the seller or the tenant, or the landlord rather, of the property. Nowhere in this form that is drafted by the California Association of Realtors does it say that the real estate licensee has any responsibility for any of that. And then, after you have gone through the scrubbing to be able to look at this property, the seller, or the landlord, is responsible for cleaning and disinfecting the property. Not the broker. The seller, or the landlord, will clean and disinfect. Now, does that mean that you have to clean and disinfect after each and every prospective purchaser who has suited up in their hazmat suit has come in and looked at the property? Because that is apparently what this form requires. The PLEAD, P-E-A-D form, for all intents and purposes, just in case you haven't gotten it, has just canceled open houses or property showings throughout the state of California for the duration of the pandemic. And the CVA form does not allow, if you sign it, does not terminate the listing based on whatever the original contract termination date is. That CVA form acts as an extension of the listing agreement until the governmental orders, all of them, state, local, federal, homeowners association, if there is such a thing, all of them have to be lifted before the clock starts again on a listing agreement that would have otherwise expired on, I don't know, April 2nd. It is very protective of the real estate brokerage community. And then we get to the last of the 4 forms, and that is the residential listing agreement coronavirus addendum or amendment. And once again, we have that word amendment because this is a form that the real estate community is suggesting that current owners who have listed their property be given for sign-off in order to maintain the listing. The issue with that, what is the additional consideration in order for an amendment to a pre-existing contract, is addressed in the form. And it says that there are mutual benefits in addressing the effects of the COVID-19 pandemic. And in consideration of those mutual benefits, the parties agree as follows. There are mutual benefits in addressing the effects. Well, how is the seller benefited by addressing those effects if all the seller is going to do is let the listing terminate based on the time that's in the existing listing agreement? Let's look at what else the form says. Once again, this form is in place until all of the governmental orders or suggestions are lifted. And with respect to those orders, they are orders that affect the property. Now, I've read Gavin Newsom's order, and it doesn't talk about property at all. It talks about people. And so how is there any order that affects property that's going to be lifted? The ambiguity in this is rife. Then, with regard to showings of property on this listing agreement, remember, you're hiring the real estate agent to sell your property, to list it, to market it, to show it, to make it available for prospective purchasers to inspect and decide whether it is something that they wish to acquire. But prospective purchasers will not be allowed to enter. Will be asked not to enter. So if you ask someone not to enter and you say you don't have permission to do so and they barge past you and enter into the property anyway, is that person now liable for trespass? Because you've just given the real estate agent the authority to bar people, and they are going to contractually ask them not to enter unless. The first thing is that this prospective purchaser must sign a statement and declare 3 things. The first is that they are not afflicted by COVID-19, nor have they been in contact with anyone afflicted by COVID-19, to the best of their knowledge. And that while on the property, they will adhere to safe practices. But what safe practices is not defined in this residential listing amendment. Then, this prospective purchaser must provide verification that they either have sufficient cash to buy the property outright, or that they have been pre-approved by a lender to get a loan for the amount necessary to buy the property. They must show that they are pre-approved, not pre-qualified, pre-approved, which means all of their credit has been analyzed, everything is ready to go. The only thing that this loan would be subject to is an appraisal and verification of the condition of the property. While it is probably a best practice for a real estate broker to have already verified that their prospective buyer client either has the cash or is pre-approved to buy the real estate, there are probably less than 3 out of 10 that have done so. And so now the barrier to entry for inspection has just been raised. And next, and somewhat humorously, the prospective purchaser must verify that they have previously viewed the property online. I guess Zillow or Realtor.com are really happy about this, because now, in order for your property to be shown, the real estate licensee must put it online to be inspected online before anybody can come into it otherwise. And if those things weren't enough, the last of the provisions in this residential listing COVID amendment or addendum is paragraph 5. And paragraph 5 contains a provision that says, the seller agrees and shall, the seller agrees to, and shall hold broker and its agent harmless from any and all claims, liabilities, obligations, attorney's fees for any actions, and shall indemnify the broker for any damages, costs, attorney's fees, or other fines from any third party that arise from or are related in any manner to this amendment or addendum. You, the seller, are now agreeing to indemnify your broker for all claims that might arise as a result of that broker's performance of its duties to show your house. I recognize that everybody is a little panic-stricken right now, and I recognize that knee-jerk reactions are oftentimes not well thought out, but these forms by the California Association of Realtors, while they are incredibly protective of the real estate community that the C.A.R. is there to serve, if I were a buyer or a seller and I were presented one of these forms, I would certainly want to have independent legal counsel review it with me so that I understood what it was that the broker was asking me to sign. If a buyer and a seller is given this form without the real estate licensee explaining the significance of the form to them, I would posit that the real estate licensee has breached its fiduciary duty to the client, because these forms change dramatically the legal positioning of the client, buyer, or seller and the real estate broker from what is already a pre-existing arrangement.